Bodie Lang here. In this video, I want to show you a breakdown of the voter fraud testimony in Georgia a few days ago. I really want to highlight the behavior of a particular person, Georgia Democrat State Senator Elena Parent, who's just awful. I mean, that's really the only way I can sum it up. She's just awful throughout the entire proceedings. And this happens because she clearly and obviously isn't listening to anything that's being said. I'll actually show you later in the video of her not paying attention when others are speaking at the hearing. She just lies and then gets destroyed by everyone who responds to her because she's not listening or she just can't comprehend what's being said. And the media is starting to come to her defense and push articles about Elena Parent being treated unfairly and how she's getting death threats and all this stuff. And she deserves the attacks she's getting because she's absolutely awful. But to kind of set this up, basically Trump's attorney opens up laying out the fraudulent voting. He says there's 2,500 felons who voted in Georgia, 66,000 underage illegal voter registrations, 2,400 plus unregistered who voted, over 1,000 who had P.O. boxes, nearly 5,000 late registrations, over 10,000 dead voters, nearly 400 from other states, almost 16,000 filed change of addresses, and over 40,000 who moved out of state or failed to register, who all voted, which is in total about 144,000 votes. And this is in a state that supposedly Trump lost by 12,000 votes. He didn't lose it, but he was defrauded of it anyway. So they start off showing this video, which many of you have probably seen already, this video of them clearing people out and saying they're stopping the voting. And then after everyone leaves, these workers under no supervision bust out suitcases of ballots hidden under a table and start counting them, which is illegal. Election counting in Georgia must be open to the public. So they show everyone the video, and here's what Democrat State Senator Elena Parent has in response.
That they've investigated this repeatedly, that they had a monitor on site the entire time. And frankly, this has been debunked for weeks by our Secretary of State's office.
I doubt he's seen the video.
Then I think the courts will probably be able to handle this once you present your evidence to them. As I'm aware, there have been about 40 lawsuits dismissed already. And according to the law of the state of Georgia, we do not have the power to submit alternate electors. The provision in the law is quite clear at 21-501F.
Is there a question?
Senator, we'll ask questions. We'll have a time for statements at the conclusion.
My question is, since this has been debunked repeatedly, what evidence can you give to us that counters what our elections officials have presented us with only an hour ago?
You just saw it. Your officials need to watch the video.
What about the fact that they say that they had a monitor there the entire time?
I can't speak for them.
Well, thank you.
They did not have the video.
They said they had a monitor the whole time.
Okay.
You're looking at the room.
There's no Secretary of State.
Then maybe we should invite them back in.
All right. Well, we may need to do that. Senator Tillery.
So you can kind of get a sense of Elena Parent's whole demeanor about these proceedings. She's just a brat.
Then maybe we should invite them back in.
All right. Well, we may need to do that.
She's a complete and total brat and a terrible listener. She responds to the video evidence by just stating that this has been debunked for weeks. No, they literally haven't had this video until the night before these proceedings. So this hasn't been debunked for weeks because the video wasn't even available. But after having the video presented before her, Democrat State Senator Elena Parent just claims this has all been debunked and asks, what evidence do you have? And the woman presenting the video is like, I literally just went through the video. This is hard video evidence of illegal and fraudulent activity. And Elena Parent just responds with, well, Fulton County said they had a monitor there the whole time. And again, everyone in the room pauses and looks around and points to the video and says, there's literally video in front of you showing there's no monitor there and them counting votes. So the officials in Fulton County are lying. You can't dismiss video evidence just because Fulton County Democrat officials lied. That's clear. The video is right in front of you. So then this professor of constitutional law comes on to discuss the legality of what the state legislators can do as far as their electors to challenge or block this fraud. And this is a guy who testified at the Florida voting debacle in 2000 in Bush versus Gore, a credible constitutional scholar. So let's just keep that in mind.
My scholarly work and expertise have always revolved around the structural provisions of the federal Constitution. And because of that, similarly, 20 years ago, I was invited to testify before the Florida legislature as they were dealing with issues similar to what you're dealing with now. At that time, no one had given much attention, scholarly or otherwise, to the role the Constitution assigns to state legislatures in determining the manner of choosing electors. And it's a little bit foreign to us now because we haven't really done what the Constitution authorizes fully for a very long time. Let me begin with the relevant provision of the U.S. Constitution that, Ray, you talked about earlier in your testimony this morning. Article 2, Section 1 provides that each state shall appoint in such manner as the legislature thereof may direct a number of electors to which they're entitled. The Supreme Court has described this constitutional authority of the state legislatures as plenary. That means it knows no other limit. That the legislature gets to do whatever. Nevertheless, the constitutional power to decide on the method for choosing electors remains exclusively with the state legislatures. Now, to be sure, the authority to take back that power and appoint electors at any time, as the Supreme Court said in McPherson, would likely not allow a legislature to pick its own slate of electors after the results of a fair election, which have been conducted pursuant to the legislature's existing statutory procedures, merely on the ground that the legislature didn't like the outcome that the popular vote had chosen. As the Supreme Court said in Bush versus Gore, when the state legislature vests the right to vote for president in its people, the right to vote as the legislature has prescribed is fundamental. But that's not the case when the existing procedures are not followed. And when significant statistical anomalies and other evidence raising serious questions about voter fraud and about whether the election was fair. In such cases, the manner for choosing electors set out by the legislature was not followed. The constitutional default of the legislature exercising its plenary power, or rather resuming that power, is therefore again brought to the forefront. As the court noted in Bush versus Gore, the right to vote in election for presidential electors is fundamental when done in the manner the legislature has prescribed. Now, what you've been hearing today is a lot of testimony about how the statutes that you had prescribed for the manner of choosing electors were not complied with. By the way, this is all in perfect line with federal statutory authority as well. Section 2 of Title 8 provides that whenever a state has held an election for the purpose of choosing electors and has failed to make a choice on the day prescribed by law, the electors may be appointed on a subsequent day in such manner as the legislature of such state may direct. The failure of state election officials to follow the manner you had set out in statutes in conducting this election, as well as the intermingling of illegal and legal ballots in significant enough numbers that the election can't be validly certified. That is what the Florida legislature was prepared to do in 2000, prior to the resolution of that state's election controversy back in 2000. The vote on that day had been certified by the Florida Secretary of State, but the state Supreme Court had, contrary to state law, ordered a recount in only heavily Democrat counties with the expectation that that would flip the vote that had been certified. The relevant committees in the Florida legislature, both houses, crafted identical resolutions that would allow the legislature to reclaim its plenary power of choosing its own slate of electors. Those resolutions passed out of the relevant committees, and they were already scheduled for floor votes where they were expected both to pass when the Supreme Court issued its decision in Bush versus Gore, making that unnecessary. Violations of Georgia election law here, which is to say the manner that the Georgia legislature has established for choosing the president electors, are numerous. As you've been hearing testimony all day today, the number of underage individuals who are allowed to register contrary to the statutory authority amounts allegedly up to approximately 66,000 people. 2,500 people who are convicted and incarcerated felons were allowed to vote and have those votes counted contrary to state law. Proofs of identity that are required under state law were not complied with. Voters, as you just heard, moving from one county to another before a 30-day window, as the statutes allow, were allowed to have their votes counted and cast in the prior county of their residence, contrary to state law. A number of voters don't even have registration of residential addresses, but P.O. boxes, and have been allowed to vote and cast ballots, contrary to state law. I think the biggest one is a result of the March 2020 settlement agreement that was entered into with your Secretary of State and certain Democrat committee challengers that effectively altered the signature verification process for your absentee ballots in ways that are contrary to state law. Those state statutes are all designed to help prevent fraud, and yet their violations now then have created a serious problem with the potential for fraud. Just on the absentee ballots itself, the signature verification process normally results in the rejection of about 3 to 4% of absentee ballots for failing to include a residential address or for signatures that clearly do not match those on registration. Because of the changed procedures as a result of that settlement agreement, and that was agreement that was entered into without any involvement of the legislature, which means it was done contrary to the U.S. Constitution's authority in Article 1, Section 2. The rejection rates in this election were like 1/3 of 1%. With the resulting about 40,000 ballots that would have been discounted or rejected historically were allowed to be cast and counted. That's a significant deviation from the manner that this legislature has set out. These significant statutory violations are, in my view, more than enough in the way of the alteration of the legislature's approved manner of choosing electors to warrant this legislature from taking back its plenary power to determine the manner of choosing electors. You could do that by calling a special election, although the time is very tight for that and may be logistically impossible. But you could also do what the Florida legislature was prepared to do, which is to adopt a slate of electors yourself. And when you add in the mix of the significant statistical anomalies and sworn affidavits and video evidence of outright election fraud, I don't think it's just your authority to do that, but quite frankly, I think you have a duty to do that, to protect the integrity of the election here in Georgia. These violations, combined with the significant evidence of fraud, in my view, strongly support the conclusion that something is amiss here, and that the legislature simply must investigate, as you're doing with this hearing today. And then if as a result of this investigation, you're convinced that the election was conducted contrary to state law, and too fraught with the risk of fraud to be properly certified, then you should exercise your prerogative to legislatively designate a slate of electors more in line with what the evidence of what actually happened on election day by valid votes demonstrated.
So this constitutional law professor basically says the legislators in Georgia have the power not to give their electoral votes to Biden on two different fronts. One of which is the mountains of evidence of fraud, and he cites some of the numbers of illegal votes that were mentioned several times throughout the proceedings. But on the other front is when the election has not been conducted according to the state statute. That alone, even without the fraud, is enough for the legislator to not certify the results and not award their electoral votes to Biden. If the legal statute is not followed and election protocols are violated, then the results are null and void. And he says this exact process unfolded in Florida in 2000 in Bush v. Gore, but the Supreme Court stepped in before any of this happened and made that unnecessary. But Florida was prepared to go that route. And he says this is the route that Georgia legislature should go. And they have a duty to go this route because clearly the election is not only fraudulent, but it was conducted illegally. And this is provable. So then Elena Parent decides to challenge this professor, and it doesn't go well.
I find all this a very interesting constitutional argument. So correct me if I'm wrong here, your argument is that essentially we have a failed election that would require the legislature to step in and assign electors. Am I correct?
Yes.
And what do you say in terms of proving that there's a failed election? What do you say to what's been laid out by our Secretary of State, Governor, Attorney General Barr, and the courts? Because right now there have not been, as far as I'm aware, proof of the number of ballots that would be required to have been problematic to switch the election and call it a failed election. I don't know where the evidence is. What do you say to that?
So I want to pause right there for a moment. Elena Parent, again, just cites other people like the Secretary of State of Georgia, Brian Kemp, the governor, and Attorney General Bill Barr, who say there's no fraud, and then just presents that as overriding evidence, which is kind of a weird approach because there's Democrats saying that hundreds of eyewitness accounts and sworn affidavits of election malfeasance is not evidence of fraud, but they will use what other people say as evidence against fraud, like Brian Kemp and Bill Barr. But then she shifts her argument a little bit. She says there's not enough evidence that enough ballots were affected to change the election, meaning she completely ignores the 144,000 fraudulent ballots that have been stated multiple times throughout the hearing. But the thing about this argument, and it kind of bothers me when I hear this argument a lot from Republicans, is like, well, was there enough fraud to change the election? The answer is yes. There's obviously more than enough fraud that could change the election, but nevertheless, it shouldn't even really matter. The fraud is obvious, it's widespread, it's organized, and you can tell by these states and municipalities all calling timeout on election night simultaneously, saying we're going to stop counting for no reason. They didn't even give a reason. Fulton County justified as some sort of water leak that never happened. They all called timeout on fraudulent grounds for no reason at all, to buy themselves time to usher in some fraudulent activity. So given the fraud is clear and one-sided, and it's across all of these battleground states, it's not like a few rogue actors, that should be enough to disqualify the Democrats. I mean, if an Olympic sprinter wins the gold medal for the 100-meter dash and then tests positive for steroids, they don't debate whether or not the steroids were sufficient to give him the edge or whether he would still have won with or without the steroids. No. None of that matters. He's disqualified. He cheated. End of story. There's a stiff penalty for cheating. You cheat, you're disqualified. Clearly, the Democrats cheated. It was organized. They should be disqualified. But anyway.
Well, there are two issues here. There's one, the extent of the fraud in the casting of ballots, and the other, which is undisputed, the failure to comply with the statutory scheme that this legislature had sent out. You can say that there's no fraud whatsoever, but if the statutory scheme is not followed, the manner of choosing electors set out by this legislature, which has the sole authority to decide what that manner is not violated. It has been violated. Okay. And therefore the election is invalid, even without any evidence of fraud.
Well, can I ask you, what is the statutory scheme that, in your opinion, was not followed?
Well, I recited several of the provisions of the state statutes that were not complied with in my testimony.
I don't have your testimony, sir. I apologize.
Yeah, no, that's all right. So I think the biggest one was the change in the signature verification process on absentee ballots that was done as a result of a settlement agreement.
I'm aware
that did not invoke the legislature.
Right.
Now, the problem with that is you had a judiciary and you had executive officials changing the statutory mechanism. The only authority to do that is the legislature.
So I understand
and the legislature did not do that.
I understand the argument. Can I, and I apologize for interrupting. I just want to get sort of the things I'm really focused on answered. So the Secretary of State's position is that the law was not changed. They just, essentially they said, this is how we're going to do it to ensure uniformity under the law through guidance to the counties, and the law wasn't changed.
Well, I mean, I've looked at the statute and I've looked at the consent decree, and the consent decree very clearly allows signature verification only of the signature on the application for absentee ballot. Whereas the law requires signature verification of both the signature on the application and the signature on file with the registration card.
But sir,
that change from or to and is a significant change.
I do believe that the procedure is you check them both, so there's signature verification 2 times.
Not according to the consent decree. It says or. It says or, and that's a significant change over the statutory scheme. It's only one of the significant changes.
Okay, but wouldn't you agree
that I recite in my testimony.
But would you agree that if the procedure is that they check it twice, that's actually preferable?
Yes, that's what the statute requires.
And I believe
but the consent decree allows it to be checked only once. The statute has a double protection there. The consent decree only has a single protection. And that's a change from the statutory protection against fraud that the legislature had adopted that was not complied with.
Well, you and I have I'm not sure that's correct. I think it's checked twice. And I think that's what the guidance said. But can we move on? And what else was statutorily not followed that, in your opinion, resulted in a failed election?
Section 21-2-216 on registration of underage voters. They're allowed to do that up to 6 months before they turn 18, if they will be 18 by the time of the election. That was not complied with. People were allowed to register to vote more than a year ahead of their 18th birthday. That looks like more than 66,000 people were illegally allowed to register and vote in violation of that statutory scheme. Felons were allowed to vote in violation of the statutory scheme. The failure to check voter identity was, requirements of state statutes were violated. Those violations of the state statute, and let me give a comparison. In North Carolina in 2018, in the congressional district number 9 there, somebody violated state statutes by doing ballot harvesting that was not allowed under Florida law. Nobody demonstrated or proved that any of those harvested ballots had been illegally cast by people who weren't proper voters. Mm-hmm. Nevertheless, the violation of the state law was enough for the state election board to order a re-election as a result. I think the same thing has gone here with these violations of the state statutes.
And if I may really briefly wrap it up. Yeah, thank you, Mr. Chairman. I'm aware of the North Carolina situation. I think the difference that at least I feel is I haven't seen any evidence of any of the things that you're talking about. So we would need some sort of court intervention. We would need a successful lawsuit. We would need the state elections board to take action the way you described happened in another state. And right now what we have is in our law 21-2501F, where the legislature has decreed that the candidate receiving the most votes is who the electors will represent. That's what we have in our law.
Well, with all due respect, the candidate receiving the most votes in an election conducted in according with all the other provisions of your state election law. When that was not done, you don't have a valid election. And this is exactly what happened in Florida when the state Supreme Court started ordering things on recounts that were contrary to state law. The Florida legislature didn't wait for a determination of a court to say our state law was violated. They made that determination themselves and passed resolution to protect their electoral votes. I mean, and it is their sole authority under Article 2 of the Constitution to do that.
So there's a lot of fraud that even the Attorney General of the United States has not found? I'm confused. I'm sorry. And you went back to the very first point you made. There doesn't have to be evidence of fraud, although I think there's rampant evidence of fraud, as you've been hearing all day today. The mere violation of your state statutes is sufficient for this to be an invalid election and to return the power to determine the manner of choosing electors to this body.
Okay, so you can tell that Elena Parent is a horrendous listener, and you can see she interrupts and refuses to listen to what he's saying. And so she looks really stupid, because if you're listening, he's saying the law was changed from requiring 2 signatures to 1 signature. Instead of checking the signature on the ballot and the registration card, the law was changed to check in either the signature on the ballot or a registration card, which effectively changes the law from verifying 2 signatures to only verifying 1. And that change was not made by the legislator, which makes it illegal and illegitimate. And Elena Parent is clearly frustrated because she's wrong and she just doesn't get it. And so she just gets wrecked. I mean, Elena Parent just gets wrecked. It's embarrassing. She gets completely wrecked, and you can see she's just dejected. You can see in her body language, she's dejected. She doesn't have anything to say other than to make some smartass remark of,
so there's a lot of fraud that even the Attorney General of the United States has not found? I'm confused. I'm sorry. And
you went back to the very first point you made.
I mean, she's just a brat. And then this professor, this constitutional law professor, has to reiterate himself that, again, there's plenty of evidence of fraud. Literally all day, people have been testifying of all sorts of nefarious activity. There's video evidence, there's statistical anomalies, there's over 144,000 illegal votes that they know about that have been mentioned several times. And because Elena Parent isn't listening or can't comprehend what's being said, she doesn't realize that even that That isn't even required to make the Georgia election illegitimate. State statutes were violated in this election, making it invalid. What is so hard to understand about this for Elena Parent? So she gets wrecked there. But then, so at the end of the hearing, the state senators make their final statements. And Democrat State Senator Elena Parent rants for like 5 to 7 minutes of just nonstop garbage. I'm not going to waste your time and playing it. I will provide a link to the hearings, and I'll try to give you a timestamp for her rant here. If you want to see it, you can. I wouldn't recommend it, but she actually argues in her final rant that they shouldn't have this hearing at all because all it does is give credibility to conspiracy theories and Republican lies, blah, blah, blah. It's pretty amazing that someone can go through hours and hours of testimony, illegal vote counting on tape, statistical anomalies, and at the end just say what she said at the very beginning of the hearing, which that there's no evidence of anything wrong or illegal and it's all just lies. Like only someone who is either stupid or dishonest or just doesn't listen could say that. And then the other senators go around the room and talk about how stunned they are at all the evidence and all the testimonies, and that clearly there's something wrong. Pretty much the opposite of what Elena Parent said, because they were actually listening. And you can look at Elena Parent. This is the closing remarks of another state official, and just look at her. There she is, busy on her phone, not listening, not paying attention. It's like a bratty little girl who doesn't really care what anyone else has to say. She knows everything and doesn't need to listen to anyone. And this is why Elena Parent is an idiot. This is why she got destroyed throughout the entire hearings and had nothing to respond with other than to continue to say that there's no evidence of fraud baselessly, even in the face of mountains of evidence of wrongdoing. Like, this is how you get stupid. Same with people like AOC, people who don't listen to what others are saying, who don't take in what they're saying, contemplate what's being said, and respond to what's being said accordingly. They don't learn anything and they remain stupid, like AOC or Elena Parent. So this is just kind of a few tidbits of the hearing where Georgia Democrat State Senator Elena Parent gets wrecked by a law professor, and her behavior throughout the entire hearings was disgusting. She's nasty. She's stupid. She's a bad listener, and she just gets destroyed the entire proceedings. So yeah, Elena Parent deserves everything she gets. And I hope people of Georgia and across the country are appalled at this woman